Welcome to this panel this morning. This panel has a tradition because we've been doing this for, I think, around about 10 years. I've forgotten when we started. The panel is co-hosted by Deutscher Anwaltsverein, the German Bar Association, who have a great office, a great and strong office here in Brussels. If you have any questions concerning the Brussels office and the activities of the Deutscher Anwaltsverein in Brussels, ask André Kutschmann, who is sitting in the second row. Co-hosting, so if there are co-hosts, there must be at least one more host. And the other host is one of the, well, I'm happy to say, leading German privacy law magazines, Privacy in Germany, which I started with a wonderful team just over 10 years ago. We have 6 editions a year, publish articles both in English and in German in a very, very traditional Berlin publishing house, Erich Schmidt. And what I like about our magazine is exactly the same thing I like about CPDP. Is anybody Austrian in the room? No, well, the Austrians would call it mélange, which is this mixture of academia, lawyers, of course, they are all over the place and everywhere, and but also all guys from the NGOs, and of course here from the Commission and all the other players here in Brussels, which leads me to introduce to my left Leonardo Cervera Navas. My Spanish is non-existent. So pardon my pronunciation. You have been in Brussels for quite a while. I heard it is since 1999.
Indeed.
Yeah, you started out at the European Commission, and you have been doing data protection since 1999. Presently, well, you have been with the EDPS, with the European but for the EDPS. For a very, very long time, and you are now their General Secretary. Leonardo, not everybody in this room will know what a General Secretary does at the EDPS. Can you explain us?
Well, thank you. First of all, thank you very much for inviting me to the Olympic Games of data protection, like Giovanni Bottarelli used to say, and for inviting me to this German session of the Olympic Games, me being a Mediterranean. I hope I can bring a little bit of sparkling wine to the room.
Cava.
Yeah. We used to have a deputy supervisor in the EDPS, but the budgetary authority in its wisdom decided that we didn't need a deputy supervisor. That with one supervisor it was enough. So we decided that we needed to upgrade the position of the director that I was occupying before to the role of Secretary General to compensate a little bit for the lack of a second person in the house. And that's my job. So I combined my work on data protection and also some work on administration. So Wojciech likes to call me his chief of staff in a very, very American way, yeah? Right? So this is more or less my job.
Okay, Leonardo, today we want to, well, look back a little bit. Let's say 6 years back, 2018, when the GDPR was still a baby. And when the GDPR was all over the place at CPDP as the AI Act is this year. And the question we want to discuss today is the question, what lessons can we learn from the GDPR for the AI Act? If you look back to the last 6 years, What would you say are the strengths and what would you say are the weaknesses of the GDPR?
Okay, so I think the answer the question and the answer I think is quite obvious. I think everybody in the room more or less would respond in the same way. But I would like to answer from, let's say, humanistic viewpoint. I think it's indisputable that the GDPR has become the global standard, and Europe has taken a great leadership in this field. I don't think anybody can dispute that. But in my view, some of the novelties brought by the GDPR compared with the Data Protection Directive, this is the fault of being around for so long, that you always compare with things that were before. But for someone like me, the GDPR brought new principles that, in my personal view, the data protection community has not yet fully internalized. And I think this is a weakness in the system. So when I started in the 90s, we had all these principles of purpose limitation, data retention, fairness, and things like that. But then, in the GDPR, the legislator created these new principles of accountability, risk-based approach, privacy by design, that, in my view, my personal view, have not been sufficiently exploited yet by the data protection community. And that, I think, is a weakness, because it doesn't allow for this legislation to be applied in a, let's say, modern way. But in itself, the structure, the house, is extremely solid. It's an example for everybody. We just need to, I don't know, to open a couple of windows here and there so the fresh air can circulate a little bit in the room, and I think we will be striking the right balance between innovation and protection of fundamental rights.
Can you explain what you mean by modern ways? I mean, we all tend to think that the GDPR is as modern as anything can be. What does the GDPR lack when you talk of modern ways?
It doesn't lack anything. I think everything is there. What I think we are lacking is making good use of these new principles that are there and are not sufficiently exploited. If the legislation, the principles of the legislation, in my view, remain the same, but what is changing is the reality to which this legislation is applying. It is obvious that the reality in the 80s or the 90s, when I started, is very different from the reality that we have today with AI scenarios, etc. So my view is that we need to implement these sound principles to the new realities in a modern way to make it fully compatible with the AI Act, for example, and the GDPR. It's not easy. It requires a lot of work. But we have a lot of experience by now in Europe, and we know how to deal with these things. So.
I remember in the years before 2018, or 2016 to be precise, I asked one of the legislators why there wasn't anything where we weren't talking of AI in those days, we were talking of big data, but we meant the same thing, why there wasn't anything specific on AI/big data in the GDPR. And the answer surprised me at the time. That was, well, we can't have something, some provision for every bit of new technology in the GDPR.
And I agree.
Looking back, was that a mistake?
No, I agree. I think that the GDPR, the strength of the GDPR is that it's technological neutral, and that it's principle based. This is, I think, where we are missing. I mean, we are looking at the tree and we are not seeing the forest. The GDPR is principle-based, and the principles are very strong and can resist the time very well. But some of these principles, because they are new probably, have not been sufficiently interiorized. And for example, when you look at the AI Act, and then you see the risk-based approach being reiterated, I think this calls for also strengthening a little bit more the risk-based approach also for the GDPR, together with the other principles. So that doesn't mean that we have to forget about the other principles, but the principle is there for a reason, so let's use it.
Let's talk about the market effects of the GDPR. If I think back 10 years ago when the GDPR was under discussion, Viviane Reding kept saying this would open up a level playing field between European actors and the big US companies from the Silicon Valley. And the hope was very much that the GDPR, hope and promise was very much that the GDPR would open up market opportunities for European companies in competition with the US giants. Has this promise come true in your view?
I think the GDPR has had clearly market effects. To start with, the extraterritorial scope of the GDPR has made the whole world market aware of data protection, which I think is a big contribution to humankind, because nowadays, no matter where you are, you have to deal with the GDPR, and I think this is fantastic. It has increased the culture of data protection everywhere, and it will have long-term effects. That's very clear. What I'm not so convinced is that the market effect in the meaning of dramatically changing some business models that are a little bit at odds with the GDPR has happened as it should. But this is not a problem with the GDPR itself. I think this is a problem with the way the GDPR is being enforced. And to the extent that there is problems with the enforcement of the GDPR, it is normal that these business models are not adapting as they should. This is a completely different topic, which is not related to the GDPR itself, but the way it is applied in the member states.
What would you regard as the number one problem we were saying with the enforcement of the GDPR?
I think the Wojciech Wiewiorowski has been very clear about this since we organized a conference precisely on that back in 2022. We think that the moment is coming for a true pan-European enforcement of the GDPR. We've been saying this for some years now, quite simply because the actors do not act nationally, they act at the European or even world level. Therefore, the enforcer has to match this reality. I could say that even a pan-European enforcer can become short, and it will be even necessary to establish some coordination with American enforcers, to be honest. But the situation at the moment, I think, is far from ideal. I know there is efforts to improve the situation, even a legislative proposal, but as we have been saying for some time, the problem is systemic. You cannot fix the situation with little things. The problem is that we have these big players, and then we have many players enforcing separately and in a way that is not ideal. So my plea would be that for the next Commission mandate, we all reflect about this.
I'm looking forward to play this ball to Markus Wünschelbaum in a moment. But let me ask you one more question. We're talking about red tape and red lines here. And red tape, that's talking about all the procedural rules that we have in the GDPR, the registries, and so forth. My impression is the big US companies are dealing quite well with all those procedural rules. They are from America, so they have compliance in their DNA. They have the resources to pay whole global teams, big global teams, to deal with all those rules. What would be your view? Who is well? I have to ask you if you agree to my observation, and what about smaller European companies who are often struggling with the rules?
Yeah, I think red tape is bad for business, is bad for competitiveness, for innovation. There should be all possible efforts to cut red tape. That's clear. At the same time, make no mistake, there is no shortcuts for the protection of fundamental rights. Companies need to understand that they need to do certain investments to make sure that they comply with this law that affects the dignity of individuals. This is very important in the new discussions about AI regulation, for example. So indeed, let's get rid of useless red tape by all means. Let's facilitate the life of small and medium companies as much as we can. But at the same time, let's not pass a message that you can go away without investing in internal compliance. We are going to have very soon very sophisticated AI tools in place, which will be fantastic, and we will be doing a lot of things, but it is unavoidable to make considerable investments in data protection and AI compliance to make sure that this is done properly. And I think this is what Europe can bring to the world. Here we believe in AI, we believe in new technologies and progress, but we think deeply that it has to be done in a human-centric way, because this is the only sustainable way. If these systems are not done in a human-centric way, they will not survive, as we are seeing now with some business models that were designed not in compliance with the GDPR, and they are struggling to survive precisely for this reason. So let's be smart, let's take this seriously, and then let's do the investments without red tape, but with taking seriously data protection. Mm-hmm.
Thank you, Leonardo, for the moment, and let's bring Markus in to my right, Markus Wünschelbaum. Great German name. Markus works for the Data Protection Agency in Hamburg. As probably most of you know, Germany is the country that does not only have one DPA, but we have 18 DPAs. Because we have 16 Länder, we have the federal DPA, and then we have Bavaria, who always do their own thing. They have 2 DPAs, one for the administrative bodies and one for private businesses. Well, let's go to Bavaria, but stay in Hamburg. Hamburg is a Bundesland, it's a country. Since fairly recently, they have a new head of the Data Protection Authority, Thomas Fuchs, and Markus Wünschelbaum, one of the rising stars of the German data protection scene. Remember him, because then you can say in 10 years' time, I already saw him in 2024 in Brussels. You're now working very closly with Thomas Fuchs because you have wonderful English. You have an English title, which is the Policy and Data Strategy Advisor. Is that correct?
Yeah,
have I remembered it correctly?
In Hamburg, very modern. We choose English words to confuse Germans.
Great. I have to, Markus, I have to ask you the question. If you hear from Leonardo that enforcement should be pan-European, while in Germany it is not even pan-German, what is your view?
My view is that is the problem. It should be pan-European, but it won't. I think that the way that the GDPR is set up and the way that the countries are structured in Europe will not allow for a pan-European structure the way it is now. And I mean, looking at the AI Act, we can see that to contribute to the topic, we have lessons learned from that. If we look at the way that we regulate in a product environment, in a product regulatory environment, it will be very different. When we have the AI Act, it won't be different member states who disagree, and then the European Data Protection Board will then discuss, and maybe there will be an opinion that then the CJEU will decide on eventually, and then everybody will fight what the CJEU exactly meant with that wording or that half sentence, looking at pay or okay. And that's a huge problem, and I think you can see in the AI Act that they saw this, and they decided to go in a different way. And the product regulation way shows us that they found something that is not one-stop shop, at the same time can be effective. Because in the end, what they said is that the Commission will be the arbitrator between the member states, which is interesting to give the Commission even more power. But it is logical from that point of view that if you see that the member states do not have a pan-European enforcement, you choose the Commission as the arbitrator, because in the AI Act, interestingly enough, it will work this way. One country, for example, will pull an AI system from the market because they believe that it doesn't comply with the AI Act. Then they inform the Commission of this. The Commission then informs all the member states. Then each member state can disagree with that decision, and then the Commission decides if this sort of disagreement has merit, or if the country that pulled the product has merit. So in the end, it will, the member state that is the most persuasive and has the better understanding of technology, the better resources, will then win out, instead of constant discussions and position papers where I was there, where you fight over every single little word. At least you will have the Commission fighting about this in itself. And I think that is a major improvement, and that is one way where we can have pan-European enforcement by having the member states participate in this process, but having someone else than the member states decide on this. And I would say that is one of the major lessons learned.
In Germany, there is a just refreshed discussion about who will be in charge of enforcing the AI Act in Germany, and the Hamburg DPA is quite active in this discussion, and reminds us all that AI will whoever the authority will be, AI will definitely remain an issue for the DPAs as well. How do you think this can work with AI being a data protection issue and an issue of the new AI Act at the same time, with probably a patchwork of authorities all over Europe being in charge? Sometimes it will be the same authorities, sometimes it will be different authorities. This all seems confusing to me. How is this supposed to work? What do you think?
It's not only confusing to you, I think. I think everybody involved is sort of confused because the problem that we have is that obviously we have, when we look at AI systems, major data processing going on, and that will not stop. And the GDPR remains untouched, unaffected, whatever word you choose. And in the end, this means that we will still have these kind of old systems of pan-European enforcement when it comes to the question of legal grounds for training, for output data. We right now have the question of discussing how do we even enforce data subject rights. Can you delete something that is in the model? Do we have personal data in the model saved? Are the means and that you have to extract data with like privacy attacks, are those enough to say that this constitutes personal data as per the Breyer decision? These intricate little discussions that pertain to data processes, those will remain a member state question. And it will remain confusing because right now we lack technological understanding of the AI systems, and with the growing understanding, we will then have to somehow harmonize this with our understanding of data process, of GDPR and data processing. That was basically to maybe also come to the point of what is one of the major weaknesses, but also wins of the GDPR. We have a culture of data processing, which is great, but the GDPR takes like little data processes and regulates them. Oh, there, one person gave consent, and we have this little thing, and then we'll regulate this. And I think the second side, what the DPAs won't regulate, because it's not data processing, is the product, the AI system itself. And I think this is the big difference, that the DPAs by nature will not ever regulate a product, not ever regulate a software, not ever regulate a platform, because that's not how the GDPR was built. And I would say that in hindsight, hindsight is always 20/20, that might have been a mistake. The technological neutrality was interesting as a foundation, but in the end, it lacks enforcement because we cannot grasp a data process in comparison to a software, a product, a system, a platform. So there will be a two-tier approach. Data privacy authorities will continue to enforce the GDPR, as confusing as it is. At the same time, we will have market surveillance authorities, hopefully strong enough, staffed well enough to pull products from the market and say, this is not okay, this is not in conformity with the AI Act. We pull this product off the market, especially when we see developments where human beings suffer, die, whatever, as a result of these products. Then the market surveillance authorities would be the first ones to react and pull a product from the market. This will be a two-tier approach. On the one hand, we'll talk about how these systems work. On the other hand, we'll take care of these systems as a whole. But let us not forget that the DPAs are in the AI Act as market surveillance authorities already. They are set for 4 out of 8 high-risk sectors when it comes to migration, when it comes to justice administration, when it comes to law enforcement and influencing elections, which is really relevant right now. The DPAs will be market surveillance authorities. So, in a sense, they will regulate this, and this does not pertain to the deployment of the AI system in a public office. Since the AI Act regulates along the value chain, this means any private entity that provides these softwares will then be regulated by DPAs. So DPAs will have to be a market surveillance authority. This is an incredible challenge. It's an incredible challenge to do this. And we will have to rise to the occasion, staff people who know their stuff and who know product regulation, because that is the problem. We do not. We need to learn this, and we are not the only ones who struggle. Talking to lawyers, privacy professionals here at this conference, everybody's struggling with this. But we especially will be struggling.
Being a privacy law litigator, occasionally acting for businesses, I'm looking forward to the argument as towards the AI Act authority, that the matter they raise is not an AI Act issue, but a GDPR issue, and to argue as towards the DPAs that a certain matter is not a data protection matter, but a GDPR, but an AI Act matter. We will see. Let me bring Christopher, who's sitting to my right, in. Christopher, I'm tempted to introduce you with a phrase including the word seasoned.
Seasoned, yeah. I'll take that.
Which I like, yeah. And we have known each other for more than 20 years, definitely, and we've been sitting on panels and at restaurant tables as last night, and in places all over the world at conferences. If there's anybody in the room, I doubt that this is the case, who doesn't know Christopher, definitely meet him, follow him all over the place, and read his books. Christopher, you're the perfect mixture of a private lawyer. That's how you started, and you're still part-time, but also a professor at Queen Mary in London, and you've been working on technology law for at least 3 decades, if I may say so. So you're the perfect expert for the questions we're discussing here today. First of all, there's one word that I won't mention today, which is Brexit. Sorry, it just slipped. But tell me, what is the situation in the UK now? Is the GDPR still in force? And will there be an AI Act similar to ours?
Right. Well, thank you for the invitation to join this panel. In terms of the history, I'm afraid it's more than 3 decades. I've been working on data protection law for 42 years as an academic and 40 years as a practitioner. And, I have some thoughts about how the law has evolved and how the practice has evolved over these years. But to address your first question, well, you may or may not have seen in the press that we're about to have a general election in the UK. And there are 16 bills before Parliament which are not finished, and there is a process called the wash-up, whereby there is a mad panic rush to get stuff on the statute book before the election, and one of the 16 bills relates specifically to data protection. And there have been concerns that were this bill to be passed in its current form, it might begin the divergence of the UK from the EU GDPR standard. Now, at the moment, it's very simple. As you know, Brexit was about taking back control and having an entirely new statute book that's not contaminated with the EU. So the way the government did that was they took things like GDPR and they changed the name. And the name of the GDPR in the UK is the UK GDPR, and it is exactly the same as the GDPR. So at the moment, we do not have a divergence issue, I would say, of any substance, and that's extremely important in terms of the UK's adequacy status, which is one of the many things much debated and argued about in the context of Brexit. So I would say it's unlikely that this particular bill will come out of the dishwasher, or whatever you say in the wash-up jargon, intact. I suspect it will go down the drain. And then we will have to wait and see, because we will have a new government and a new legislative program sometime later this year.
Are there plans to follow in the footsteps of the EU as far as the Acts are concerned?
Yes. Well, I can't speak for the UK government, but what I have heard is that the current administration, which will probably not win the next general election, but we will see, as Yogi Berra said, it's dangerous to make predictions, especially about the future. So I'll leave that on one side. But the current administration has been saying, yes, AI is absolutely transformative. The UK wants to be a leader globally in this. And we probably won't take exactly the same approach as the EU has taken. And the idea is to have an approach that's more about facilitating R&D, research and development, and product development, and making the UK an attractive place for players from all over the world who want to, among other things, get into the European market.
Which sounds like something completely different.
Not necessarily. It sounds like we don't know.
Okay, let me get into red tape and red lines. And let me ask you a very, very simple question. What do you think of the AI Act, the European one?
That's it's a long document and it's a long discussion. I have some concerns that we say in English, neither fish nor fowl. So it looks like on the one hand, it's a product liability measure, and on the other hand, it's something completely different to do with, as others have said, the entire ecosystem and the life cycle and all the data. And it is a mixture, a bit like GDPR actually, of very high-level principles combined with extremely granular and specifications of things you can and cannot do, and very detailed processes you have to go through to even find out whether you can or cannot do them. We already have that with GDPR. There is a great deal of red tape, and it is being added layer on layer. And one of the concerns I have at the principles and conceptual level, and here I will show my age, when I started work in the City of London as a data protection lawyer in 1984, we had a brand new Data Protection Act, the UK Data Protection Act 1984. And it had principles which are very similar to those you'll find along the way in the directive and more recently in GDPR. And it's not surprising they're similar because they were all based on the Council of Europe Convention, which had already been around for a few years. And there was we did have some red tape, I must confess. So the regulator was called the registrar, because the data protection registrar's primary job was to keep the register. And here we are in the classroom. I hope you have all signed in so that you can get credit for this class. But so the registrar kept the register, and the registrar had some powers, like he, and it was a he, could impose enforcement notices, including specifically transfer prohibition notices for international transfers. But what has surprised me as data protection law has evolved over the last 40 years is that we still don't know what the basic concepts mean. We are still discussing what is personal data, who is a controller, who is a processor, who is a subprocessor, who is a joint controller. And some of these things, even more fundamental, you could argue, is what is the lawful basis for processing? That is still on the table as an unresolved issue, and the EDPB has been very busy putting out quite interesting documents, shall we say, and many of the other regulators individually have been doing that. So it concerns me that if after 40 years we can't answer these basic questions, are we really ready for more principles-based regulation of the type that we see in AI? And one other general comment about regulation, again, based on my experience over the years, is that 10 years after I started as a data protection lawyer, I thought I was going to diversify a bit. So I became what was in the day called the internet lawyer. So this was the early 1990s when for the first time people heard about the World Wide Web, and they were amazed to see there were a handful of people on the internet already. And there were calls around the world, some of them very agitated, saying there ought to be a law against this, or there must be a law at least to regulate this new internet thing. And if we don't do that, our entire civilization will be destroyed, and our entire legal systems will collapse. And there were some interesting challenges. So suddenly, laws all over the world simultaneously would apply to what happened on a website. But I wrote a paper actually in 1995 called Cyberspace and the No Regulation Fallacy. And my argument was at that time nothing in history had been more regulated than the internet and activities carried out online. And I called for a pause. Now, we've had people saying we need a pause in the development of large language models, which was, I think, a bit of a well, it's interesting, but it was more virtue signaling. It was never going to happen because the cat is out of the bag. You can't put it back in. But I thought it was a good idea for governments and legislators to pause before they enacted even more laws, because the internet was already flooded with regulation. Here we are, 30 years after the internet excitement, and everybody says we need lots of laws to regulate AI. And I would say AI, again, like the internet, is already massively regulated with existing laws, including data protection laws.
Would you think there are, red tape or red lines? Would you think there are a lot of red lines? A lot of clear statement what is not allowed and what is allowed?
Well, there's a lot of red ink, and there are lines, but they keep moving and they intersect each other, and some of them appear to cancel each other out. So I would say the red lines are not at all clear. And this is really bad news for people that are involved in innovation, and they are wanting to build products that are safe and that are compliant with all of this existing corpus of law and regulation I've already mentioned, because it's a moving target. And, you know, if you are a tech company and in good faith, having consulted with lawyers and regulators, you say, we will build our business on this lawful basis for processing. And then a regulator or a court comes along and says, sorry, you can't do that. You say, okay, we're listening, we'll try this other one. Say, sorry, you can't do that either. And they say, okay, well, there's one left, we'll try that. And then they say, you can't use that one either. So what do you do? I mean, it's extremely uncertain. And I do advise clients as well as doing academic research and teaching in this field. And it's very hard to give a straight answer, even about the red lines.
There's a lot of discussion about, well, both in data protection, if a good example, somebody already mentioned the pay or okay issue. This is the issue of targeted advertising. The reality is, if I may simplify, that if you do 100 risks analysis and put them all on file, you will find a way to do a lot. And I always wonder that if this, it's not my view that if targeted advertising is regarded as a very, very serious issue and risk, why are there no bans defined of targeted advertising? And the same is this, and I think the same can be said about the AI Act, that if you're a bit cynical, it's mainly work for us lawyers to prepare all, to file a lot of stuff to prove that clients, companies, or whoever we're working for are compliant.
Yes, well, I actually agree with you on that. I would say, to put it bluntly, the GDPR has been one of Europe's biggest own goals, to use a soccer analogy, if I may, because far from making it a level playing field and far from facilitating innovation and growth of tech companies in the EU, the opposite has happened. And indeed, we put out a paper 6 years ago, just when GDPR was coming fully into effect, and we called it Compliance as a Service. And we argued that GDPR was so complicated in terms of process and compliance obligations and tracking information and reporting, etc., and even dealing with data subject rights. It's very complicated for many organizations. The consequence we predicted would be that there would be a massive growth in the privacy industry, if I can call that, and we've seen that. So organizations like the IPP, International Association of Privacy Professionals, grown exponentially thanks to GDPR. And companies have stepped into the breach, because even large organizations like government agencies and large multinational companies struggle to deal with the very detailed red tape that has come out of GDPR. So we have compliance as a service, and it turns out that the companies best placed to help with compliance as a service are the biggest tech companies. And so that was, again, a prediction we made 6 years ago, was that the hyperscaler cloud providers, in particular the really big three, which are Amazon, Microsoft, and Google, would offer compliance as a service, and they all do now. There are some things you can get for free, there are some things you can get for a subscription or for specific payments. And meanwhile, the legal profession, the privacy professionals more broadly, massive explosion in the ranks. Now, I'd say that was probably an unintended consequence, even though it was predictable. I don't think it's helped EU businesses, either providers of services or users of services, but it's been a huge gift to the US.
I think, Christopher, it's time now to, well, I was about to say to go back to the Mediterranean, which is not quite true because we are going to the Atlantic. If I may introduce to my very left, Ichazo Dominguez de Olazabal, who is a policy advisor at European Digital Rights, and I'm sure you're just waiting to comment on what Christopher just said. Let me just try and put Christopher's words in my own words. Would you? Well, I'm sure you won't agree that that what the GDPR has mainly produced and what the AI Act might also produce is work for the privacy industry, for the privacy professionals. And I'm sure you won't agree that while you can argue about the pros and cons of the GDPR for all kinds of groups, businesses, citizens, etc., there is one group of people who are clearly profiting from the GDPR, and that is us lawyers and the privacy professionals. Would you agree to this very sort of, you may say, cynical view?
Yeah, I've never seen a market research on that, so I will guess you're just by logical inference that this is the case. You could argue, if you want to be cynical, that civil society organizations, and in this case digital rights organizations, have also grown, but for reason, because we are here to protect a fundamental right. And I think we keep speaking about principles, but at the end of the day, we're speaking about fundamental right that is included in the Charter, that is included in international law and should be protected as such. And this is something that we shouldn't be forgetting at any time.
And let me just ask you to just explain to us, there may be some people in the room who are not too familiar with European digital rights. This is a network of more than 40 companies,
yes.
40 NGOs.
And
NGOs. But you can
so,
explain much better.
So we are a network of more than 50 NGOs, academics, and experts working on digital rights all throughout not just the European Union, but also Europe, as the Council of Europe defines it. And all of us are fighting for a correct enforcement of the GDPR. This is why I forgot to say it's an honor to be here together with the DPS and with such experts on the matter.
Of course, we will all agree that data protection is important. We will all agree that privacy is important. We will all agree that it is a fundamental right, and that we wouldn't all be sitting here in this more than crowded room if this wasn't about fundamental rights. But I mean, still, shouldn't we discuss about whether we can do better than the GDPR?
Whether we can do so, sorry?
Whether we can do better, or whether we can improve the GDPR, and whether we can learn lessons from the GDPR?
Oh, I'm sure we can learn lessons. I think the GDPR is, as my colleague said, is a very complete text. Sorry, it's a very comprehensive, complete text that has problems when it comes to the enforcement, but this is why we have a proposal from the Commission that is nowadays being discussed by the Council, because the European Parliament also adopted its process, and we are all for an improving of the enforcement process. We've been identifying all of the problems. We have also seen that all of these big tech companies are the main actors taking advantage of these insufficiencies when it comes to enforcement, particularly when it comes to a very specific business model that is maybe not banned, as you say, but that has proved really harmful when it comes to fundamental rights, but also when it comes to other societal values, for example, moral harms or even safety of the people. One of the questions that I think you plan to ask me, I think it's this idea of red lines, because it's also included in the titles, and this is when working with civil society, red lines is something that we are really comfortable, because at the end of the day, we all should have red lines. And we had red lines when it came to GDPR, which were all of these principles that you were speaking, and one of our biggest red lines was also this new principle that you were referring to, this idea of data protection by design and by default, which is also an opportunity for companies. Let's not kid ourselves. But we also had red lines when it comes to AI Act, and it's true that I don't want to differ with you, but it's true that EDRI and other digital rights organizations consider that the GDPR is more of a rights-based text than a risk-based text, even though there's risk assessment in specific situations. And this is something that we also believe that the AI Act should be, not this idea of risk-based approach, only those those operations or those softwares that will require high risk or that would entail theoretically, and again, this is something that we need to be calculating at every step of the way, but any kind of AI, because we know how unpredictable that is, will require to be focused on the rights that are fundamentally harmed or put at risk by the mere idea of how AI works. This is when we started speaking about biometric mass surveillance. This was a red line for us. I don't think I need to explain why, but maybe if you want me to do so. Predictive policing, biometric categorization, and emotion recognition, social scoring. We've seen how harmful that is for fundamental rights beyond the borders of the European Union. And this is the problem with the AI Act, that all of these narratives around, we need more innovation, we need the biggest amount of data as possible, whereas there's companies who keep piling up on data and are actually not using the data and are actually do not know where the data is at, and that we have realized after all of these 6 years of enforcement. So instead of obsessing with this idea that the more data, the better for the society, which is completely not true. The more data, the better for the companies, which I'm sure it is not true, except for a number of big tech companies whose business model is based on putting at risk fundamental rights. Again, I'm being really, really annoying, but I think fundamental rights should be at the center of all of this discussion. Maybe instead of, falling prey to this gaslighting of we need more data, maybe we need to understand how innovation could be profitable to, of course, investors, to, of course, companies, but also to the society as a whole, and in this case, to citizens and individuals in the European Union. In this implies less profit, and this is, for example, the debate that we are having with Pay or OK. What's the problem with Pay or OK? As Professor Millard mentioned, there's companies who have been trying once and again to try not to comply with GDPR, and it's true that some texts have been adopted by the European Union that have not banned this surveillance advertising, but we still have the court.
And that's actually the opposite to what I said. They are trying lots of ways to comply.
They're trying, and still apparently they are not getting what they want because Pay or OK doesn't comply with GDPR and doesn't respect fundamental rights. But even if a practice is not banned, even if a business model is not banned, and maybe it will eventually be banned because this is what most citizens want, according to some of the preliminary studies that we have the court. And the court is the ultimate guarantor of our rights. And when they have had to decide, they have decided in favor of fundamental rights and applying correctly, but also comprehensively, the GDPR without exceptions, without exemptions.
If I may just ask Leonardo a quick question, and because I think it's a good targeted advertising, because it's a big subject, is a good example. I'm sure you will share Itacho's critical view of targeted advertising. So may I ask you, why wasn't targeted advertising, at least in some contexts, banned in the GDPR? That would have saved us a lot of court cases, discussions, and uncertainty that we are still in. I mean, it must be, it's not my view, but from your point of view, this must be a deficiency of the GDPR.
Well, maybe we can put the question to my dear colleague Thomas Serdik, who was one of the persons holding the pen when the GDPR was drafted. But my answer to this will be, I am a very pragmatic person, because I think Europe needs more pragmatism, and Europe needs to wake up to the world we are living, which is becoming very dangerous and very competitive. So when you go to the Museum of History of the United States in the mall, it is there clearly explained that it was advertising that made the United States the superpower that it became. So really, advertising in the 20th century and probably in the 21st century is one of those things that money makes the world go around, right? So it's a very, very, very important business. So I suspect that this was one of the reasons why it was decided not to really go into that, because I think we need to look at the bigger picture here. And the bigger picture was to put the GDPR adopted and to make the breakthrough that we did. And perhaps had we gone to this specific problem, the whole thing could have been derailed, I suspect. But maybe, Thomas, maybe you can give us a yes, please.
Do we have a mic for Thomas?
There's nothing better than the person who was in the room, right? So
there was indeed an early draft of the GDPR which provided for an opt-in for marketing, basically advertising. And as a result, as Brussels works, with a promise that, of course, direct marketing and advertising companies would absolutely comply 100% in the future with the future GDPR, that was then reverted back to the situation of the Directive 95, basically saying everybody can do direct marketing and advertising, but you have a right to object. So that was the promise, but we see that seemingly it's entirely very difficult to comply 100% or even a little bit. So I think now the discussion should be really out there. This is a business model which by definition cannot comply. So indeed, it needs to be forbidden.
Thank you, Thomas. We shouldn't.
I'm not so.
Yes, that sounds like a red line, I think.
My personal view would be that we need to find ways to improve compliance with the GDPR. I believe this is a business that deserves respect, and we need to engage. But there is certainly room for improvement, in my view.
Christopher, you're taking notes, so I pass over to you. But we shouldn't discuss discuss just targeted advertising now. Although I'm the one to blame because I brought it up. But on the well, just on the queue of red lines, what is your view there?
Well, I will use, if I may, targeted advertising as a segue. So there was an interesting and lengthy paper published by the European Data Protection Board on Pay-or-OK, which appears to be targeted regulatory action, ironically, targeted at one specific company, which is not named. And, you know, you're allowed to name it. It's not an individual, this company. It's not a living, identifiable individual. It's a big company, actually. And we've just heard... A
four-letter company.
Well, a four-letter word, indeed. And we've just heard from this intervention here that their entire business model should be declared illegal. Well, that is interesting. However, I want to move on from targeted advertising, and I think there is a broader issue at stake here that relates to what I said earlier about attempts by European governments and European institutions to compete on the global stage with global technology companies, which historically have all come from the US. Now some are coming from China, but they are not coming from the European Union. And we are currently working on 3 papers on data sovereignty and digital sovereignty. One is already available for download from SRN. 2 more will be out in the next 3 or 4 months. And having gone into a lot of detail on this, our tentative conclusion is that data protection is often used as a trade instrument. It is declared to be entirely about fundamental rights and the rights of the individuals, but when you look at the way it is implemented in practice, particularly between the EU and the United States, it looks like it is being used as a trade instrument. So that's what I would say about that.
Mm-hmm. Maybe we should, I saw that there are questions, so let's open this up now. And I saw your hand first. And where's the microphone? Please, please. No, the gentleman in front.
Hello. Yeah. Thank you. It's not so much a question, it's simply an objection to the use of targeted advertising as a appropriate term for this.
Yeah.
The more proper term would be surveillance marketing. And in terms of respect, it deserves as an industry, I would below par of the asbestos mining, maybe slightly above par of the tobacco industry. And seriously, calling it targeted marketing is really not doing justice to the unbridled gathering and exchange of personal data to an extent that even the Stasi in their wildest dreams will not have been able of. This is fundamentally incompatible with democracy and the rule of law.
If I may pass on to the lady over there, we all know what we're talking about, and the discussion that you're opening up is a discussion that we all know and all have our views on. I don't think this is the right place to start this discussion. We all know it by heart.
Can I ask my question? Yeah, thanks so much. I have a question maybe coming back more from the procedural perspective here, because Leonardo, you were mentioning the centralization of enforcement, and also Marcus was mentioning it. So my question is how to do this? Which authority, EDPS, EDPB, or the Commission? Because outside of the AI Act, where the Commission has the powers, it's not the only one new regulations where the Commission is getting new powers on the enforcement when it comes to the supranational level. And my question is perhaps, is this the only regulatory solution here? Should the Commission have this much power in so many different dimensions? Not only the digital rights, it's the problem of general application, other areas of law, they have the same issue. So maybe perhaps that's the time for reflection also on that, and whether this is the only way to regulate the EU law. So thanks so much.
I would like to hear what Itaksho says to that first, because this is a digital rights issue. If you want this all in the hands of the Commission, which is the European government.
I don't have a strong feeling about the European Commission needed to be the one to step in. I think, but for example, when it comes to enforcement of the GDPR, the EDPB should have a much stronger role in cooperation with other authorities, because we are also seeing this trend that DPAs are becoming competition authorities, and we were speaking about that with AI, how the DPAs do not have the knowledge, and they shouldn't. They are not required to have the knowledge. So when it comes to enforcement, the position of EDRI will be that the EDPB has a bigger role than it has, and that it's debatable whether the GDPR allows for that, but we believe they do, and that the DPAs should act in cooperation with other authorities, with the EDPS, with competition authorities, in order to face all of these matters that are becoming more and more complex. Again, when it comes to the Commission having this biggest role, and we also see that the DSA, even though it puts a lot in the hands of the new DSCs, depending, the Commission also has a really important role, DMA as well. And so I really believe that the Commission and all of the EU institutions should focus on enforcement throughout this new mandate. I believe we are exhausted of new regulation, especially when it comes to digital regulation, even though banning surveillance advertising should be on the cards. But enforcement is one of our priorities when it comes to GDPR, when it comes to other files, and afterwards, when we realize what are the insufficiencies of enforcement, as we have seen with GDPR, maybe we can think about regulating. But for example, this eternal debate about reopening the GDPR, which I don't think this is the case, we are completely against. Especially if you're speaking about red tape, all of these companies, the ones who have cared to become compliant with the GDPR, and I acknowledge that there's a problem with SMEs, but that shouldn't be, they should be exempt from GDPR, but that they should receive more help and assistance from the EDPB, from the DPAs, from the industry. That should be important. But let's focus on enforcement, and enforcement which is rights focused and mainstreaming human rights and fundamental rights at all times. I'm not sure I answered your question. Really.
If I may just, I think I would like to hear your view. To me, it seems odd, and now I will beat you and go back to 1983. Oh. You mentioned 1984. 1983 was the year when in Germany by decision of the German Constitutional Court, the fundamental right of data protection was born. In those days, data protection was all about protecting the citizen from a state that is, from the government that is trying to collect information about their citizens. Then we had a period of at least 20 years when the DPAs all over Europe were fighting for their independence, that they were not a government institution. Now I find it very, very odd that we should trust the European government, which is even, less, well, we can only vote for it indirectly, in contrast to the governments of all member states, that we should entrust the European Commission with all these powers in order to protect citizens' rights. I find that very, very strange.
Well, that's a big topic. I mean, some would say the European Commission has a conflict of interest because it has multiple roles in this whole matter, some of which are potentially in tension. But I would say there's another power that we haven't talked about, which is the Court of Justice of the European Union, which, in terms of generating red tape, I think should get the first prize, really the gold medal. And an example I give you is a particular case where they managed to create overnight hundreds of millions of joint controllers, most of whom didn't even know they were controllers, never mind joint controllers. And in response to that, the tech industry, having thought it was a processor, now was a joint controller and had to put in place contracts with over 100 million, now 200 million individuals and SMEs. Now, that is pretty impressive in terms of generating new red tape, and I expect you know what the case was, but I just want to give you a quote from the Advocate General in his opinion in that case. It's well worth reading. It's quite entertaining. He has a good sense of humor, and he's interested in science fiction and literature. He said, though in this particular quote, he said, "Making everyone responsible means that no one will in fact be responsible. There ought to be at least a reasonable correlation between power, control, and responsibility." And I would say in the specific context of joint controllers being jointly responsible when in fact usually one party has no knowledge and no real control, that is not helpful.
This is not.
I saw Baron raise his hand. Where is the microphone? Baron, on my left.
Baron Soka, Tech Freedom, thank you. I think this has been the best panel so far of the conference, and I really applaud Leonardo's call for pragmatism. So I'd like to ask you, if you took seriously the need for pragmatism in a world of intense competition, what would be your recommendations for how to change either the text or the implementation of GDPR so as to help European companies actually succeed and compete?
Said too much. Do you want this guy to answer that?
I thought the question was directed at Leonardo, but I can also...
Okay, I will give it a shot, but I think we are in the European Union, and we are a very special and unique region in the world nowadays, where we uphold deeply our respect of fundamental rights, democracy, and the rule of law. Therefore, what we have to do is to engage, I think, in a mature debate. That's why I think, Professor, you're trying to do today, and I congratulate you for that, to do a little bit of self-criticism and to look at the lessons learned from the GDPR and to not removing the foundations of this house, which I think are very solid, and the envy of the world, really to reflect carefully and in a democratic way, hearing all the voices, where there is room for improvement. There are some fundamental constitutional limitations, for example. So this idea of the Commission taking up a role, it's impossible because it has to be an independent data protection authority. Therefore, the Commission cannot play a role here. And then it doesn't necessarily need to be the EDPS, doesn't necessarily need to be the EDPB, but we believe there must be a way, a pan-European way. So Europe speaks with one voice when we confront these big companies. And this is what we are trying to do from the EDPS, from moderation, from pragmatism, things like that. It is not our role to regulate. This is for the legislator. But I think this message of moderation and respect, this is our DNA. This is the way we do things in Europe. And this is the way Wojciech Wieborowski and myself, we are going around the world with this message, and we will continue doing so. I don't know if this answers your question, but...
Maybe to add on to that, I think one of the major problems of the GDPR, and to go back to this topic too, why the AI Act is different from this, is that the GDPR was put into force and then left alone. Left alone for the DPAs to interpret, left alone for the CJU every couple of years give a decision where you can't really make head or tail of it. And that was the main issue of the GDPR. The AI Act specifically now has guidances where the Commission, you may disagree that the Commission does this as a body, but where the Commission has to issue guidances, listen to stakeholders, they're forced to do this. If you write to them, they will answer you, I tried. And they also have the power to have delegated acts. And this is the great thing about the AI Act. It acknowledges that we do not know now what will happen to this technology.
Yes.
It acknowledges that we will maybe only find out what we have to regulate. Yes. This is something that the GDPR did not do, maybe because we thought that we had it figured out, I don't know, but it would just remain the internet that we know, it would just remain digital marketing. But the thing is that these leeways, these rooms to specify are a major breakthrough because it means that we have agile legislation and agile regulation. Who then will specify it? If it's the Commission or the EDPS or the European Data Protection Board, doesn't matter. But what we need in the GDPR is leeway because it is in some ways outdated in the ways that I mentioned, that we have this intricate system that doesn't talk about software, that doesn't talk about platforms, but about data processing. It's not enough, and it needs to be changed in this way, that we have leeway and talk about how we should change the GDPR.
Thank you, Markus. If you, with your permission, just a few closing remarks on this panel. Well, let's wait and see whether we will be all back in this classroom or another in, let's say, 8 years' time and talk about the lessons learned from the AI Act. And let's wait and see whether the optimistic view that Markus just had, whether this will stay the test of time. We all don't know. What we do know is that European elections are coming up in a few days' time, you can now say. So we will have a new commission, and we can and our views on the GDPR in this room and on this panel vary greatly. But I think what we can all agree, if we admit it or not, on is that the GDPR is not perfect, has its deficiencies. So what we can all hope for, in my view, is that with the new Commission, there will be a chance to work on the deficiencies of the GDPR and to get over this phase where we just always write the sentence in the GDPR remains untouched in all the without prejudice. Yeah. I think that is something that we could, and whatever our views are on the details, that is probably something that most of us, at least, could agree on. So, thank you very much to my panelists here, and thank you very much for all of you to all of you to hold out until the bitter end. Yeah, and the bitter end means lunch, I guess. Thank you very much.